be held accountable. You will be held accountable.
You got it. Okay. All right, we're all set. Thank you.
You'll be held accountable, asshole.
Hey everyone, welcome back to today's video. We're looking at a man who comes into court already acting disrespectful and somehow manages to make his situation worse each time he speaks. His behavior keeps pushing him deeper into trouble, and it becomes clear very quickly that he has no idea how badly he's hurting his own case. As we go through the clip, you'll see how his attitude turns a simple situation into a much bigger problem. Let's get started and break down exactly what went wrong here.
Good afternoon.
Good afternoon.
Might I have your name, please?
I can't hardly hear you. It's
I'm sorry?
Jeffrey Bloom.
All right, Mr. Bloom. Mr. Bloom, we're here on a felony complaint today. As such, you're entitled to be represented by counsel.
I can't hear you. They got some kind of air thing going on.
I'm not sure why you keep looking around. That sound you're reacting to isn't coming from anywhere in this room. It's coming from your own mind. It's happening because you're not focusing on what's being said, and it shows how little attention you're actually paying. If you would take a moment to listen carefully, you'd realize the situation is much clearer than you're making it. Staying present and understanding what's going on will help you far more than getting distracted. Let's try to move forward with that in mind.
All right, I'll speak up. We're here today on a felony complaint. You're entitled to have to be represented by counsel. If you cannot afford an attorney, the court will appoint one for you. Do you wish me to do that?
Yes, sir. I don't know why I'm being arraigned without having an attorney anyway.
This is the first opportunity that you've got to have the court to appoint an attorney for you. That's why.
So this isn't an arraignment?
Yes, this is an arraignment on a felony complaint.
Aren't I supposed to have an attorney present during my arraignment?
Did you not hear what the magistrate just said? He's trying to ask whether you want a court-appointed attorney. Since this is your very first appearance, the court hasn't had the opportunity to assign one to you yet. They're giving you a chance to make that choice, so you can have proper legal help moving forward. It's important to respond clearly so the court knows how you want to proceed. Let's make sure you understand the question before we continue.
Yes, you are, if you want one. Did you hear what I said?
Yes, Your Honor.
If you can't afford an attorney, the court will appoint one for you.
Yes, Your
My
Honor.
question to you is, do you want me to do that?
Yes, Your Honor.
Okay, now we're cooking. Now you have an attorney. All right, Ms. Reed, how do you wish to proceed?
As I did not have a chance to meet with Mr. Bloom, we would appreciate having the complaint read on the record, but we will stand mute.
All right, well, you do want me to read it though, do you not?
Yes, I do.
Okay, so one count complaint for domestic violence, felony complaint. It's alleged that on or about July 11th of 2022, Mr. Bloom did make an assault or an assault and battery upon Tiffany Dell, a resident or former resident of his household, and or his spouse and or an individual with whom he has a dating relationship, contrary to the laws of the state of Michigan. This is a misdemeanor punishable by 93 days in jail and or a fine of $500. However, this is a third offense. So now that it's a third offense, it gets moved up to a felony, which is punishable by up to 5 years and or $5,000 in fines. All right?
Understood, Judge. He's here on a domestic violence charge, and this is his third time facing the same type of offense. His history shows a pattern the court needs to take seriously. Let's check whether the prosecutor has the same understanding of the situation and see if they want to add anything about his past cases. Their input will help clarify what the court should consider moving forward.
Judge, this defendant has a highly assaultive criminal history. He actually was on probation, which I didn't know when I filled out the bond form, but he was on probation for felonious assault when he committed this domestic violence third offense. So therefore, I'm asking the court to deny his bond based on that and based on the fact that they are both violent felonies. And I believe he's a threat to the community. His criminal history, it's purely assaultive in nature. And like I said, he was on probation for a highly assaultive crime, so I'm asking you to deny bond. Thank you.
Okay, thank you. Ms. Reed?
Yes, thank you. We would like to ask for, at the very least, a low cash bond so that Mr. Bloom can earn credit for time served in this matter. I do understand that he also does have that probation violation hearing, I believe maybe later this afternoon. If he did not already check in there, I believe that docket started at 1:30. And so I understand the prosecution's position, and I do understand that initially they were asking for a $20,000 cash or surety bond. And so we would just like to ask for a low cash bond so that he could begin earning credit for time served.
Anything further? All right, bond is set at $200,000 cash or surety.
What?
He said the bond is set at $200,000. Richard, the reason it's this high is because you're already on probation for a previous assault, and now you've been charged with a third domestic-related incident. Your record shows a repeated pattern that the court has to take seriously. Anyone watching can understand why this raises major concerns about public safety. The prosecutor recognizes it, and the judge wants to make sure you understand exactly why the amount is so high. If you're asking to be released while this case continues, the court is setting strict conditions to protect others. That's why the judge decided that your release would require a $200,000 bond.
I believe he does pose a risk to the community. He has a significant assaultive history.
Wow.
We'll set his probable cause for July 21st. Obviously, he's not going to do a waiver. So July 21st at 9 o'clock, probable cause conference.
Excuse me, Your Honor.
Anything further? Yeah.
Don't they have 14 days on a felony case to have preliminary examination within 14 days?
Wow. The arraignment took place on July 12th, and his next court date is scheduled for July 21st. That's a simple difference of 9 days. 9 is clearly less than 14, which means the timeline is well within the allowed range. It's a straightforward calculation, but he's acting as if it's far more complicated than it really is. The court laid out the dates clearly, and anyone paying attention can see there's nothing unusual or confusing about the schedule. This kind of misunderstanding just shows how easily he gets lost in basic details that should be simple to follow.
Okay, well, another thing is there was never a dating relationship here.
This is not the place to argue your case.
Okay.
This is an arraignment. You tell it to the judge.
Yes, Your Honor.
And the conditions, if you are released on bond, you're not to go to 9-8 in Ypsilanti.
Is that where you live, sir?
I went over there a couple days. She called.
Lot 91. I'm sorry, I didn't get the lot in there.
I don't want you to talk about the facts, sir. I just wanted to know if that was where you live.
No.
Okay, perfect.
Okay.
There was no dating relationship. There was no. I didn't.
Okay, that's fine.
Look,
That's fine.
Mr. Bloom, let me talk. Okay. Otherwise, you're just going to be sitting there for a long time.
That's a tough outcome, Judge. You and I both know he's not going to be able to post a $200,000 bond, which means he'll likely be staying in custody for quite a while. The amount makes it clear that the court wants to take every precaution, and realistically, he won't be getting out anytime soon. It's a strong decision, but one that reflects the seriousness of his situation and the pattern shown in his previous cases.
You're not to have any contact with Tiffany Dale or BISDL. In the event that you are able to post bond, you are ordered to wear a GPS tether.
Okay, Your Honor. One more thing, Your Honor, and I'll be quiet. I'll go back. I'll do whatever you say.
Okay. It's your case. Go ahead.
Exactly. This is your case, and what you choose to say can either help you or make things harder. If you want to keep talking, you're doing so on the official record and directly in front of the prosecutor. Anything you say right now can be used against you later, so you need to understand the risk you're taking. If you continue down this path, We'll see very quickly how your own words might end up creating more problems for you. Let's hope you think carefully before speaking further.
I didn't commit a crime here. She called me.
Don't
Okay.
talk about the facts of the case.
Okay, well, this needs to be said.
Mr. Bloom.
I know, but
Mr.
you do not
Bloom,
need to
let-
say
let
it
me
right
warn
now.
you.
I advise you
Ms.
to.
Reed is trying to.
You really don't want to keep talking because whatever you say now will almost certainly be used against you at a future court hearing. It's important to understand how serious that is before you continue. Honestly, moments like this make me feel like I should start a whole new series called People Who Reveal Too Much on Zoom Court, because situations like this happen far more often than they should. Some folks just don't realize how quickly their own words can create problems, especially when everything is being recorded. It's a reminder that staying quiet can sometimes protect you more than you think.
Your Honor.
Well, you don't need to say this. Anything you say right now
That's
can
fine.
and will
That's
be
fine.
used against you at
That's
trial.
fine. I don't care. I don't care. She needs help. She needs help. She's
The court
Ms.
cannot do
Reed,
anything
I
about
think
that.
we're done here
got
unless you have
warrants.
anything
She's got
further.
warrants for her arrest, Your Honor.
Hold on a second. You're not just putting yourself at risk with what you're saying, you're also revealing details about the other person involved in this situation. Sharing information like that helps no one, especially when it doesn't benefit you in any way. There's a big difference between explaining your side and giving out details that could create more problems for someone else. Doing that out of frustration or spite only makes the situation look worse for you. It really seems like you're trying to shift attention away from your own actions by pointing fingers, and that's never a good strategy in court. Moments like this truly show how important it is to stay calm, think clearly, and avoid saying things that can harm both you and others.
And she's an alcoholic.
further
She can't
from your-
function
Law
without
enforcement will
alcohol.
handle that on their own. We do not need to discuss that here.
She
Please,
needs help. Okay.
that is
you
not
let me
something we
know
can
tonight.
address today.
I'm letting the court know that she needs help, and you're
Okay,
denying
thank
her-
you. Thank you. Thank
You're
you.
denying her the help that she needs.
The court cannot do anything about that today.
You will be held accountable. You will be held accountable.
You got it. Okay. All
You'll
right,
be
we're all set.
accountable.
Thank you.
You'll be held accountable, asshole.
All right, everyone, that brings us to the end of the video. The main point here is simple: treat people with respect, stay out of trouble, and don't share unnecessary details that can cause problems for you or anyone else. Staying calm and responsible will always take you much further than reacting out of anger. If you enjoyed this video, feel free to leave a like, and if it wasn't your favorite, a dislike is fine too. Your feedback helps a lot. Make sure to drop a comment below, and don't forget to subscribe with notifications turned on so you never miss any of my upcoming content. Thanks for watching, and I'll see you in the next one.